Howdy, and welcome to Chapter 7 of Kosseff, including the Fourth Amendment. There's going to be a couple of videos for this chapter, and this one may be a little bit long. However, stick with me. You'll find this very interesting, and this we're getting to the heart of the course on things like how the Fourth Amendment is applied in the digital age, how we look at many of these elements of case law and try to apply them, and some of the conflicts we're having now between the different courts, between law and technology. The Fourth Amendment of the Constitution of the United States protects individuals from unreasonable search and seizure. So I've put in red here the key words, and remember this was written back in the 1700s. So the right of the people to be secure in their papers and effects, all right, what does effects mean in 2019? Against unreasonable search and seizure, search looking for something, seizure taking something, and reasonable, that problematic, well, was it reasonable? Well, how do we define reasonableness? Shall not be violated, so must be there, and no warrants to issue but upon probable cause, not beyond a reasonable doubt, not preponderance of the evidence, not clear and convincing evidence, none of those. None of those. Those are in the courtroom. Here it's just probable cause. It's a much lower standard, but it is a standard. And supported by oath or affirmation, which means when you see on TV where the policeman says, oh, I'll go get a search warrant, they almost act like they go down to a vending machine, hit a couple of buttons and get it. That is not true. It is a written document, and that policeman or government agent or whoever signs on an oath or affirmation that they believe that there is probable cause for this warrant. And then the next problematic issue is particularly describing the place to be searched. Again, don't think about this in physical. The book highlights in Chapter 7 the information aspects. Now, here's what you have to remember about the Fourth Amendment. It does not restrict private parties. If your employer searches your locker, you have no Fourth Amendment protection. That's an employer. That's not the government. That's not an agent of the government. Someone asked me, what if you work for the government? Typically, when you work for the government, you will sign documents or you will be notified that you waive this right on government premises. Then there's something called the exclusionary rule, and this is why we have to be very careful on the Fourth Amendment, and that is if the government violates the Fourth Amendment, all evidence gathered during the search or seizure cannot be admitted. So the search warrant was invalid to go into the house, and they found all this evidence indicative of a crime. But guess what? Since the search warrant was invalid, then anything they pick up cannot be admitted. Now, there's an exception to this that the government will say, well, if it had been discovered by legal means, if we would have found it another way, and there is an exclusion or an exception to just about everything. So also remember that any of your Bill of Rights applies to the states through the 14th Amendment. So you have Fourth Amendment protection rights at the federal, state, local, it doesn't matter if it's a government or agent of the government. So there are exclusions to the Fourth Amendment. So you can consent to search. And oh, by the way, the courts have repeatedly ruled that the government must inform you of your Miranda rights. However, the government has no such obligation to inform you of your Fourth Amendment rights. So if a car is stopped and the policeman says, do you have drugs in the car? Yes. Where do you have them? Glove box. May I search the glove box? Yes. You have waived, that individual has waived their Fourth Amendment protection. So that is interesting that you don't have to be informed of Fourth Amendment. So sometimes there's a lot of ignorance where people don't realize they can say, no, I don't consent to the search. But not true of the Fifth Amendment rights. You must be Mirandized at the point of arrest. Also, there's a difference for motor vehicle searches that goes back to 1925. There's the exception that says, was something in plain view? You'll see this a lot in TV shows. Well, it was in plain view, whether in the automobile, whether in the house, whether in a restaurant. I don't need a search warrant if the drugs are there and visible. Exigent circumstances, there's a list of these. The biggest one is if you're under arrest, the police have a right to search you without a warrant. there's all different things where someone will be waiting for a warrant to get into a house, let's say, and they think they hear someone screaming, there's imminent danger, so they go on and go into the house. There's all these that the courts have realized that sometimes there's exceptions to this. And the big one is also border searches. Border searches are random. You don't need a search warrant at all for nothing. And you don't need any kind of probable cause. You're in line coming back into this country. You can be pulled out for any reason, for no reason, and have your personal files searched at random. That's standing law. It hasn't been ruled on by the Supreme Court, but if you look at the map for the 4th and 9th, here's the 9th. My gosh, that's California, very liberal court out of San Francisco. Yep, border searches, don't have to have a reason. There's been a couple of cases with this. And also the 4th, which of course includes the DC area. So we're going to talk about 2 cases, and they were set in different electronic ages, but remember the law is based on precedent, so Katz is still good law. Katz was a bookie who made bets over a phone booth, and by the way, if you don't know what a phone booth is, this is what the phone booth is. The FBI wiretapped the phone booth not by the call itself, but by putting a device on the outside wall of the phone booth. There was no physical incursion. Up until 1967, the legal precedent was Olmstead, which would have allowed this. But the courts in the United States, the Supreme Courts in the 60s and 70s, began to take a more protective stance on privacy. And this is what established the words you will hear, expectation of privacy. Did he have an expectation of privacy? And the court ruled he did, and that the government erred in not having a 4th Amendment. Now, if they'd had a search warrant, the evidence would have held. But you have an expectation of privacy. Well, let's go back up here. I don't see anywhere the words expectation of privacy. But now this has been inferred by the Supreme Court of the United States. Okay, so the government, Justice Potter, Stuart Potter, I put it there, I know it when I see it. Justice Potter is Justice Stewart is very famous for ruling on a pornography case once, and in legal reasoning he said, I can't define it, I don't know it, but I know it when I see it. With pornography, I feel sometimes that's the way we look at privacy. I can't define it, I can't tell you exactly what it is, but I know what I see violations of privacy. Okay, so this is his ruling. He wrote the majority, and his thing was, regardless of the location, you have a reasonable expectation of privacy. And by the way, don't be fooled by thinking of technical terms. When we talk wiretapping, first of all, it's a search, but the way they use wiretap in the law is any monitoring of electronic communication. It doesn't have to be a wiretap. It can be software sitting on a network picking up communications, but what came out of this is the physical intrusion is not necessary, which had been under Olmstead. Olmstead had said there has to be a physical intrusion for a 4th Amendment. And then, what's better than 1 phone booth, 2 phone booths? And would you have a reasonable expectation of privacy if you're talking in a phone booth there that doesn't have walls? Well, I don't know. And, you got to think about this on your mobile phone. If you're in public and using it, is it a reasonable expectation of privacy? So I want to walk through the 4th Amendment analysis, 5 steps. So the government will say, first of all, or the courts will say, was a search or seizure conducted by a government entity or government agent? The government can't say, hey, I'm going to get out of this by hiring some people as contractors. They're not going to be the government per se. They're going to be working for the government. No. The court knows that. If it's by a private party, analysis over. 4th Amendment only protects from the government. Did the search or seizure intrude upon an individual's privacy interest? Did you have that expectation of privacy? Did the government have a warrant? If there was no warrant, did some exception apply that said you don't need a warrant? And was the search or seizure reasonable under the totality of the circumstances? So let's go back to and remember this term, particularly describing the place to be searched and the persons or things to be searched. So when you say here, was the search or seizure reasonable? Did it have reasonable limits on it? Did it particularly describe what needed to be done? So the next decision we're going to come out with is Carpenter. And Carpenter came out last summer. And I wanted to get to this. I should have brought this up earlier, but hey, I didn't, so we will bring it up now. And the reason I'm bringing this up is this was several months before the court decision was rendered. And this is an article, in just an easy-to-read article about the discussions, the oral arguments that were heard. There's a couple here, and I'm going to leave this for you to read, but Justice Sonia Sotomayor, for example, said she feared a dragnet sweep on the part of the government, and she noted that cell phones have become an appendage for people in the modern era. Mr. Carpenter was part of a group that was robbing cell phone stores. Now, this is 8-9 years ago by now. One of the group was captured. He gave up the other members of the group. They used circumstantial evidence that Mr. Carpenter's phone with its geolocation, which by today's standards is very primitive, put him in the vicinity of those crimes. Mr. Carpenter argued that they needed a search warrant to get that information. The government argued on long-standing precedent they did not. So Carpenter is a landmark decision because we see the court now begin to shift to say, wait a minute, our cell phones, as Sonia Sotomayor says, are appendages. They're appendages. We have them with us all the time. Does a third-party doctrine still apply? So we could see that from Sonia Sotomayor. She is very liberal. And Justice Elena Kagan, again, very liberal, worried about long-term surveillance, 24/7 tracking. But the one that got me in November when this case was being heard is when I saw Chief Justice John Roberts' comment. And this summarizes it very nicely. And by the way, there's more extensive articles. I picked up an easy-to-read one. Seemed to disagree that the government's position that the collected information belonged to the cell service company and did not implicate the privacy of the customer. The person helps the company create the record by being there and sending out the pings. There's other arguments here, but the important thing about this decision, it came out in June of 2018. It was the first time in a long time we have seen a swing away from the government's power to the individual's power of privacy. Now, listen to what I'm going to say. It's a very narrow ruling. And the justice even put in this does not repeal the third-party document. And this will get into our next topic, the Electronic Communications Privacy Act, and the different things there that was put in statutory law beginning in the 80s to protect privacy. So the ECPA has 3 parts, and we're going to spend the next lecture talking about these in more detail. But I want you to look at those parts. First of all, I want you to look at this. This was 1986. It restricts the government access to stored communications. Now, yes, these laws were passed in 86. There's been some periodic amendments, but sometimes even without amendments, they do enlarge your scope. So the Stored Communications Act restricts the government access to emails and the cloud. The Wiretap Act, and don't let that word fool you, it restricts the government's ability to monitor communications in transit. Not the old wiretap, you know, the guy sitting in the van with the earphone in, you know, with a wiretap, hardwired. No, this can be software, this can be anything. And the Pen Register Act restricts the government's access to non-content information. Now, I misspelled a word here. Let's get that taken care of. So the third-party doctrine is that the government does not require a search warrant to access if shared with a third party. That's what Carpenter overturned, okay? The government said, hey, his cell phone data is with the cell phone provider. So that goes back to this, but this is related to our next topic on the ECPA, and these are the 3 sections of that law we're going to talk about. All right, I'm going to leave it there for our next video. Back with you soon. Thank you for staying with me.